everybody. This is attorney ATTY Frekhtman, a New York City personal injury trial attorney. And today I wanted to talk about the lawsuit process. So a lot of clients were texting me and some were making comments on the last videos we did, and they were asking about us to talk about the process. How does a lawsuit work? What are the stages? How does a claim work? If someone is injured, what do they do? And what are all the steps that they take on the journey, right, from the beginning all the way up to the end? So basically, if you are injured in any type of accident, like a car crash, a trip and fall, a ceiling collapse, usually what you want to do is get medical care right away, go to a hospital or urgent care. That will definitely help. And the next thing you would want to do is contact an attorney. It's better to do it early and contact a qualified personal injury attorney who has experience handling personal injury cases. You don't want to go to an attorney that's a jack of all trades and a master of none, because a lot of these attorneys are doing like divorces or family law, or immigration, real estate, wills, and then all of a sudden they get a personal injury case and they think, look, I'll just do it too. I mean, they could do it if it's a small case, like a few thousand, 5 or 10,000, but if it's a big case, it's just not in your best interest to go to an attorney like that. In fact, so many times clients text me and they want to transfer their case over to us from an attorney, but oftentimes we can't take it because the case is already, it's already too late. If something's already ruined that we can't undo. It's really hard to undo something, like when you cook a steak, if the steak is already, let's say, well done, well, it's well done. You can't make it medium rare anymore. Right? It's kind of like that. It's, we try to help. Sometimes we do take cases that have been handled by other attorneys before, but we much prefer to take a case right from the get-go, right from the inception. That's much better because then we can work it up in the right way. We could build it the right way. We could do all of the steps that we're going to talk about in this video. So what are the important steps? So number one, you have to do a full investigation. Go to the scene, find out what happened, interview all the witnesses, get witness statements, do a deep dive. Depending on the type of case, there are a lot of resources out there. And I've talked about it in other videos. One of the resources, for example, with premises cases, is you could just go online and you can do a deed search. There's something known as the DAP portal where you could find out if anyone had complained about the condition before, such as, let's say, a broken step in a building or other conditions. People could complain to the HPD or to the Department of Buildings. There could be violations. Those are all really helpful, and you have to do a deep dive to find that out. You can do FOIL searches, Freedom of Information Law. And so in a car crash case, it's good to go to the scene, just look at it, take photographs. A lot of it can be done with Google Maps, but I always like to go to the scene as well, especially for a serious injury. And then also, depending on the case, you may need to hire an investigator, and the investigator may need to go out there and do their own research, such as an engineer or a safety expert. You'd want to get that in a, let's say, a trip and fall case where it's unclear. The engineer could find, the safety expert will find violations, and then those can be used to prove negligence. In some cases, if you have a violation of a statute, that is negligence as a matter of law. So the jury almost like has to find negligence, right? It's in the pattern jury instructions. It says if this statute was violated, like in a car crash case, if this statute of the vehicle and traffic law was violated, or if this rule was violated, that is negligence. You can find negligence right from that. So it's much more concrete, as opposed to something like saying, oh, were they reasonable? So some people could say, yes, they were reasonable. Some people could say, no, they weren't reasonable. And, reasonable is just such an open-ended question, whereas here you have a concrete statute, violation of a code, an ordinance, and then it's much stronger. So then that's the investigation. So we like to do that. Of course, it's very important to meet with the client, find out their story. It's very important to coordinate the client's medical care. If they have a serious injury, get them to the right doctors right away. If they have traumatic brain injury, they should go to a neurologist. They should do neuroimaging, such as a radiologist, a neuroradiologist. They need neuropsychology. So it gets a little bit complicated. If they have more of a back injury, they could start with physical therapy, but then they'll need an MRI to get a diagnosis, and then possibly an orthopedic surgeon if they need to go that route, or start with pain management and see how it goes, and hopefully they get better. But if they don't, then they may need that surgery, like a fusion surgery, either to the neck or to the lower back. So, it's very important to coordinate their medical care. And then once you coordinate their medical care, once you're done with that and they're done with their treatment, which could be, could be a while. Some people treat for 3 months. Sometimes people treat for 6 months. I've had clients who've treated for more than a year or are still treating because their injuries are so serious. They're life-changing injuries. They have to just keep treating. They can't stop treating. And they just need it for their medical health to get better. So they just keep going to doctors. And so you have to, monitor that. But once you have a concrete diagnosis and you have some evidence of injury, like you have a surgery, you have a fracture, you have an MRI, you can file a lawsuit. And then you file the lawsuit, and then you wait for the insurance company to appoint a counsel, to hire a lawyer to answer. And that means answer is really just to appear in the lawsuit, and they answer the complaint, they appear in the lawsuit. Once they appear in New York, that's called issue joinder, right? Issue is joined because now you have both sides, the plaintiff and the defendant or defendants, if you have many of them. And now you can then ask for a preliminary conference with the judge. And at the preliminary conference, the judge will say, okay, plaintiff, you give them documents like authorizations for medical records. Defendants, you give them documents such as responses to their requests for discovery, like questions about, your maintenance records or your property damage photos, if it's a car crash, whatever discovery that you ask for. And then they'll schedule depositions. So the plaintiff will be deposed or ask questions. How did the incident happen? What are your injuries? What did you used to do before that you can't do now? And then the same thing, we will ask questions of the defendant. If it's a car crash case, a lot of the questions center around the crash, the time, the distance. Did they see the other car before the actual crash? Where were they looking? What were they doing? All the different types of deposition questions. And then that all gets transcribed. There's a court reporter that types it all up, a stenographer, and then you have a transcript of that. And so then after depositions are done, the defendants can also ask for an independent medical examination, which isn't really independent. I've done other videos about that. It's really a defense medical examination. What they do is they send the injured party to their doctor, and their doctor, paid by the insurance company, paid by the defense, will invariably say that this individual is not injured, or the injury was not caused by the crash or the incident, the fall. It was caused by something else. It was caused by degeneration, the normal aging process, living your life. Or it was caused by some other incident. Maybe they had an incident 10 years ago, but just not by this incident, right? Because that's the one you're suing us for. So it cannot be caused by this incident. And it's almost like laughable. They always come up with the same with the same conclusion. So sometimes I call them jukebox witnesses, because they're like a jukebox. You show up to the jukebox, you put in money, you pick the song that you want to play, and then it plays the song. You put in money like to this witness, right? You pay them like whatever they pay them, $5,000, $10,000. And then they tell them, hey, they don't even let you do an IME, like they call it, unless, I just had that happen in a case that I'm handling where the IME was already scheduled and they were going to go to the IME. And then they say, oh, wait a minute, we can't do this IME. You know why? Because the defense lawyer didn't do his consult with the doctor. So obviously the defense lawyer hired by the insurance company has to consult with the doctor and say, doctor, you better say that this guy's not hurt, blah, blah, whatever they talk about. I'm not privy to the actual consult, but that's a reason why they adjourn their own medical examination, So that's just something that happens sometimes. And it's really horrible. It's really like a messed up system, but, we have to take it as it is. But getting back to it, so this IME is something that people have to go to. Usually it's like 1 or 2. Sometimes there are multiple. Like I had one comment where somebody was asked to go to 5 different IMEs. So sometimes there are multiple IMEs. Usually in New York, you'll only get multiple IMEs if you have multiple injuries. Like for example, if you have a neurologist treating you, an orthopedist treating you, a pain management doctor, and they think it's a really big case, and they may send you to their neurologist, pain management doctor, orthopedist, so they have the same doctors that the plaintiff has. But for the most part, it's usually like 1 IME. If you have a case, like a serious case where you've had pain management and then later on you end up having a fusion, then usually what they'll do is they'll just send you to a neurosurgeon that does fusions, and that'll be their IME doctor. They're not going to send you to like a pain management and a physical therapist and all these chiropractor and all these different doctors for the most part. So then after the IME is done, what you do then is, for the most part, I mean, if everything else is done, you can file a note of issue. And what that means is that you're certifying the case as trial ready. So you're ready to go to trial. And if it was available, you can go to trial tomorrow, right? But in New York, because there are a lot of people, there are a lot of cases, there are a lot of courts, what they usually do is they make you wait another year or even longer, and you're on the trial calendar. And in that time, you can have a pre-trial conference, you can have a settlement conference. You're free to set up your own like mediation or just try to settle the case amongst yourselves. But the court will usually do a settlement conference and a pre-trial conference. And then they have something known as JCP, which is the jury coordinating part. And they'll tell you, you're in JCP and you have to show up JCP a few times, usually like 3 or 4 times. And they'll have what's known as standards and goals. And that is the deadline by which the court thinks your case will be resolved. And before the pandemic, usually in Brooklyn and Queens and a lot of the counties, what they would do is they would say 2 weeks before standards and goals, you have to be ready to pick a jury, or else you have to settle. Or if you don't settle, sometimes they would let you transfer the case to civil court and continue the case. A few months later, it'll show up in civil court. Or if you don't do any of that, then the case just gets dismissed, right? There's no way to adjourn anymore. You have to go to trial. And they would be very, very protective of their docket, right? Because the judges don't want to be the judge that just lets cases linger. They want to say, hey, if the case is meeting standards and goals, I'm sending it out to pick a jury, or it's getting settled. All the cases are being disposed one way or another. So I think they're still doing that now. It maybe changed a little bit. The only county that really needs to speed it up is probably like the Bronx, because all the other counties are pretty much, doing pretty well with the calendar, but the Bronx is a little bit slow. So that's usually how it works here in New York in terms of the process. And then, of course, if you don't settle, then you have the trial itself, where you pick a jury that's known as voir dire. You speak to jurors and you get people that are fair. Then you have an opening statement where you tell them what you believe the evidence is going to show. You put on witnesses such as your client, experts, doctors, lay witnesses, before and after witnesses, people that knew how you were before, that can talk about how your life has changed, whatever witnesses you want to call. And then the defendant puts on their witnesses and you get to cross-examine their witnesses. And then you get to give a closing statement, and then the jury goes and deliberates. And then usually the way the verdict works is they will answer certain questions, like, was the defendant negligent? Yes or no? Was the negligence a substantial factor in causing the injury? If it was a substantial factor, if it was a cause of the incident, then yes, then you win. If it wasn't, then that's one of the ways that a case could be lost. And then they'll say that if the defendant was negligent and the negligence was a cause of the injury or the incident, then what happens is they'll say, well, state a fair and reasonable amount that's going to be just to compensate them for the past pain and suffering, for the future pain and suffering, and the same for like economic damages, medical expenses, whatever damages you prove during the trial. So they could be economics, like lost salary, and they could also be non-economics, like the pain, the suffering, the loss of enjoyment of life. That's a big one that we really focus on and try to build up. So that's mostly the process of how everything works. And, maybe I could do more specific videos about each stage, because, that's a very general overview of the process. Each stage has the real nitty-gritty. So we could talk about, if anyone has questions, drop them in the chat, and we could talk about any particular questions you have, and I could do more videos about each specific part of the process. But that's an overview for the entire process. Now, that's the process if you file a lawsuit. Of course, you don't have to file a lawsuit. You can settle the case, right? If you, going back to the more like the beginning of this video when I talked about doing the investigation, having your medical treatment, at that point, if you decide not to file a lawsuit, once you're done with your medical care, if your lawyer sends what's known as a settlement package or a settlement letter to the insurance company and then just negotiates with them, and if they offer you an amount, you can settle it as a claim. Usually those are reserved for smaller cases. I would say like 10, 15, 20,000. I haven't seen too many cases settle without a lawsuit that settled for, let's say, hundreds of thousands of dollars. I mean, it can happen. We actually had one, I think, that settled for over $250,000 as a claim. But for the most part, it doesn't happen. Usually, you need to file a lawsuit to get the maximum compensation. So I hope this has been helpful. Let us know what other questions you have. And remember, we are here to help you. Our mission is helping serious injury victims and their families, and we are here for you. So let us know how we can help, and thank you for watching. Like and subscribe to our channel so we can make more videos, and we look forward to speaking with you very soon. Have a great day. Bye-bye.